Hi, I'm James Minick, and today we're going to talk about how to attack the admissibility of a breath test in North Carolina where a person being asked to do the breath test was denied a witness during testing procedures. In North Carolina, a defendant has to show three things to show that his right to a witness during breath testing was denied. First of all, he has to show that he actually requested a witness to be present during testing procedures. Secondly, he must show that the witness timely arrived to view the testing procedures. And then finally, he must show that the witness, upon arrival, made reasonable efforts to gain access to the defendant. So those are the three things that a person must show. In North Carolina, under 20-16.2, a person does have a right to have a witness during breath testing, during the intoxilizer test. The defendant can waive that right. The easiest way to determine whether or not the defendant requested a witness is to look at the Refusal Rights form. It's form DHHS 4081. And on that form, there will be a box indicating whether or not the defendant requested a witness. A box for yes, the defendant requested a witness, or a box no, check no. If the defendant requests a witness, there is some supportive case law under State versus Hatley that the officer now has kind of an affirmative duty to notify the front desk. There wasn't a part of the Hatley holding, but in dicta, the court in Hatley basically said that if the officer knows that a witness is coming to view testing procedures, they should alert the magistrate or the front desk officer to make sure that that witness can then timely get back to see the defendant. Secondly, the witness must timely arrive. This is a difficult thing to show sometimes in the courtroom. You may use phone records showing text messages or phone calls. There may be a jail surveillance video showing that the witness is actually in the lobby prior to the administration of the breath test. But this can be a difficult piece to show because there's a very short window, a 30-minute window, that the witness must timely arrive in. Finally, the defendant must show that the witness made reasonable efforts to gain access to the defendant. And so in terms of arriving at jail, how quickly did they go talk to the magistrate? What did they tell the magistrate about the reason they were there? The case of State versus Hatley specifically states that the witness need not come in and tell the magistrate, I am here to view a breath test. There is no requirement that the witness use specific language in terms of explaining why they are present at the jail. In Hatley, the witness told the front desk officer, I am here for Debbie Hatley, who was charged with DUI. And that was effectively the entirety of the conversation that was recorded in terms of the appeal of the meaningful conversation between the front desk officer and the witness. And the court found that that was sufficient and reasonable efforts by the witness to gain access to Ms. Hatley. The court in Hatley said, we find no authority for the proposition that a potential witness to an intoxilizer test must state unequivocally and specifically that he or she has been called to view the test before the witness is permitted to observe the test. Uncontradicted evidence shows that the witness timely arrived, identified and described to the front desk officer the person she was there to see, and told the front desk officer that she was there for a DUI. The court found that that was sufficient in that case. That was reasonable efforts by the witness. The court's logic really appears to be that there, and this is something to express to your own judge, is that it is the charging officer, the chemical analyst, the magistrate on duty, the front desk officer or sheriff at the jail. It's these people that deal with DWI or other charges on a routine basis, that they deal with these things on a daily basis. They know the procedures around the intoxilizer. A person that is suspected of DWI and that person's friends and family that are coming to act as a witness have very little context or legal knowledge, knowledge of legal vocabulary that would allow them to kind of exercise their rights in a kind of thought out way. It's really, the onus should be on the state to make sure that as many steps are taken to protect the defendant's rights, the suspect's rights, as possible. They're the ones that have the kind of daily knowledge of these type of charges and the procedures that should be in place. So remind your court of the common sense reasoning behind the Hatley decision. Just a couple of things that the state may argue in terms of challenging whether or not your client has been denied access to a witness. First of all, you may hear the argument that the witness's presence would not have changed the intoxilizer result. That is true, but irrelevant. Don't let the state kind of hang their hat on that particular issue. In Hatley, the result was a .11. The question is whether a violation of the statutory right or constitutional right has occurred. The question is not whether or not the number itself would have changed. Red herring number 2, the witness was allowed to see the defendant shortly after testing. You may hear that from the state, that just after testing they were allowed access. That may be helpful in terms of defending the state, defending against a null motion to dismiss, but it doesn't help in terms of finding out whether or not there was a violation of the statutory or constitutional right to a witness during breath testing. And then finally, you might hear the state argue that there were signs posted in the jail about how a witness was supposed to act. Again, that's not the question. Hatley lays out, and it follows in Ferguson's footsteps, Hatley lays out what the requirement is, and the legal standard is that the witness make reasonable efforts to gain access to the defendant. And in Hatley, those reasonable efforts were explaining who the person was that the witness was there to see and that they've been charged with DWI. The remedy for a violation of a person's right to a witness could be twofold. Under Ferguson, the remedy was dismissal because the defendant was denied a witness at a time that was critical to the defense, and that was for the intoxilizer purposes. Ferguson was decided in 1998. It's not a terribly old case, and so remind the court that the violation in Ferguson was considered substantial and significant enough, prejudicial enough to warrant dismissal. You can also argue under State versus Hatley and that line of cases that the statutory right to have a witness present during testing under 20-16.2 should result in suppression of the breath test, and that in fact is what the Hatley court found to be the appropriate remedy.